All right, so good evening. Welcome to those who are joining live, and for those who are going to be watching the recording, I appreciate it. Happy Thanksgiving to those who celebrated it. Hopefully, you had time to spend with family and friends. And welcome to our second to last week of May It Please the Court. So, recall that this workshop is focused on exploring the interaction between the U.S. Supreme Court and federal, state, and/or local policy and political institutions, actors, and behaviors. The live Zoom's held on Tuesdays from 8 to 8:30. And this is our fall schedule. So week 1 and 2, we went over, gave overview of the federal judiciary and of the Supreme Court. And then for weeks 3, 4, 5, we listened to case 1, which was Tennessee versus Mississippi. That actually was decided last week, but we'll talk about the end. And then case 2 is the U.S. versus Texas, which we're listening to now. So let's go ahead and jump to case 2, the United States versus Texas, and recall the question that's being asked of the court to answer, which is, can the United States sue the state of Texas in federal court to prohibit enforcement of an unconstitutional abortion law? So we'll go ahead and jump to 2610 time mark, because that's where we're at, and we'll get to it. All right. And if you can just give a thumbs up with the audio, if you can hear it, that'd be great.
I share some of the concerns that have been voiced by my colleagues. You say this case is very narrow, it's rare, it's particularly problematic, but the authority you assert to respond to it is as broad as can be. It's equity. You said we have the authority to sue states under equity, which is a limitless, ill-defined authority. And I just wonder, I know you've been asked this question before, but if you could repeat your answer. What is the limiting principle? When we get another case down the road where it's a different Solicitor General who's making this argument in a different case, what are we going to be able to point to that says, no, you can't invoke that broad equity power, or you can't say just because there's a state statute that is enforced by private parties, which is a very common phenomenon, that you then get to sue the states?
Well, Mr. Chief Justice, the equitable remedy that we're seeking here is not limitless. It is the traditional remedy of enjoining implementation of an unconstitutional law. And the limiting principle that will
Well, it's hardly traditional to get injunctions against judges, injunctions against clerks, injunctions against everybody, right? That's part of the relief you seek, isn't it? Anybody can bring one of these suits, so you're seeking an injunction against the world, right?
No, we're seeking an injunction against those who actually choose to involve themselves in the constitutional violation by filing suit.
Well, so anybody can do that. But anyway, I'm sorry.
It's true. I just wanted to be very clear that the injunction doesn't apply to the potential plaintiffs, only to the actual plaintiffs. But to try to address the concern you've raised, I think that here the limiting principle arises from the way this statute operates to try to deprive any meaningful review anywhere, whether in federal court at the outset, whether in state court on the back end through the enforcement proceedings. And I recognize that this seems like a novel case, and that's because it's a novel law. But we do not think that a recognition here that the United States can intervene to try to protect the supremacy of federal law would open the floodgates in the mine run situations where a state is simply applying a private right of action through ordinary and fair state court proceedings.
Justice Thomas?
No questions.
Justice Breyer? Justice Alito?
As to the potential private plaintiffs, how can they be bound under Rule 65 of the Federal Rules of Civil Procedure? With what party are they acting in concert?
They're acting in concert with the state of Texas, which has created the bounty that incentivizes their conduct and has created the apparatus through the enforcement proceedings that allow them to perpetuate this constitutional violation.
With the state, not with any individual who is a party?
That's right. We believe that they act in concert with the state, which is the named defendant here and bound by the injunction.
So would any private plaintiff bringing any common law tort suit be acting in concert with the state under the laws of which that claim is asserted?
No, but there's a world of difference between an ordinary private right of action and the exercise of that kind of private enforcement and what SB 8 contemplates.
No, I understand that, but why is the question whether they're acting in concert with the state any different? Here they're acting in concert with Texas, you say, because they are bringing suit under a Texas law. So if somebody brings suit in Maryland under Maryland defamation law, they're acting in concert with Maryland. Is that right?
No, and we're not suggesting that every private right of action is governed by these same principles. But the key difference here is that the individuals who are SB 8 plaintiffs are actually exercising the state's own enforcement authority. This is not meant to remedy some private harm that those individuals suffered. And I think the best example or illustration of that is that the $10,000 plus bounty that the state has created is only available to the first comer. And so the suggestion that was made earlier by Texas that this could be some redress for personal outrage, I think is inconsistent with how the scheme is structured. This is meant to simply function as a method of encouraging the suits to be filed on the state's behalf. And in that circumstance, we think it can qualify as active concert or participation.
The Texas Constitution requires injury in fact, and this statute, as I understand it, permits an award of actual damages in addition to the liquidated damages. And there's nothing particularly unusual about a statute that provides for liquidated damages. So I don't understand your answer at all.
Well, Justice Alito, if that's what the statute was attempting to accomplish, then presumably it would apply those liquidated damages to every single SB 8 plaintiff. It wouldn't limit it to just the first person who is able to effectively bring to bear the coercive force of the state's enforcement authority. And so the suggestion here that the $10,000 is meant to provide a presumptive dollar amount on personal injury, I think is inconsistent with how the statute operates.
All right. So one final question. The federal rules do provide a mechanism for you to do what I gather you're trying to do with respect to these potential private plaintiffs, and that is to certify a defendant class. Did you try to do that? Have you satisfied the requirements of Rule 23 to do that?
We did not try to do that. And again, I think this relates to my answer to the Chief Justice that the injunction doesn't reach the world at large or every possible person, but anyone, anywhere who is authorized under this law to bring suit. Instead, it's narrowly focused on those individuals who choose affirmatively to exercise the enforcement authority by filing suit.
Mrs. Sotomayor?
What happens to your lawsuit if we were to find that whole women's health is justiciable?
I think that wouldn't retroactively operate to extinguish the sovereign injury that the United States experienced when Texas passed this law and clearly attempted to thwart judicial review at a time when the law was unsettled. But I do think that if this court clarified in Whole Women's Health that the providers can move forward with their suit, and if it forcefully rejected Texas's effort here to stymie that kind of federal court review, then we wouldn't have the same sovereign interest in a future case, because at that point the law would be settled and this attempted circumvention would clearly not work, and so
they can't sue the state the way you can because of sovereign immunity. So one of the big issues for them, and I'm not asking you to litigate their case, but I'm asking for your views of how it affects yours, is who do they sue? They haven't sued like you have all SB 8 plaintiffs who file suit. They've sued a clerk of the court, a judge, and attorney general and other state officials. So how do they get the relief that you're seeking? You've heard Justice Alito say not everybody has been named because the SB 8 plaintiffs have not been named. So how can they be bound?
That's right, Justice Sotomayor, and I think that reflects that the relief that we're seeking is in some respects different than the relief that the providers could obtain in their suit, because they don't have a mechanism to identify or sue the SB 8 plaintiffs. Here, our injunction can rightly reach those plaintiffs because the state of Texas is subject to our suit, and then the plaintiffs can be bound under Rule 65. I think that the providers, therefore, have rightly focused on trying to target the aspect of the enforcement proceedings that create the harm through the filing of the cases in the first place. And I understand that to be the basis of their request that the court recognize their claim as against the clerk class.
Thank you.
Justice Kagan?
Well, is it also possible that in the whole women's health suit, that the AG could stand in for the individual plaintiffs in the way that in your suit, the state essentially stands in for the individual plaintiffs?
I think that is possible, Justice Kagan, and so if this court concluded that the AG of Texas could properly be enjoined here in the provider's suit, then that effectively, I think, would pierce the fiction here that the state has tried to create by delegating the AG's enforcement authority to the world at large, and could rightly try to target that aspect of the enforcement scheme.
Justice Gorsuch?
General, are you aware of a precedent that permits an injunction against all persons in the country, the world, the cosmos who bring suit?
No, Justice Gorsuch.
So
our injunction doesn't do that either.
But you said it against anyone who brings suit, right? So I did include that in my limitation. Am I missing something?
Just to be clear, and I'm sorry if I wasn't clear about this before, we understand the injunction only to bind those individuals who choose to file a suit. And
yeah,
so
that's
that,
my
at
question.
that point, they would be
I'm
identifiable.
asking you, counsel, are you aware of any other example of such an injunction?
With that specific term, I can't cite one to you. Again,
not in the history of the United States. You can't identify one for us, right?
In the history of the United States, no state has done what Texas has done here.
And then, with respect to those individuals who would be bound, could they, for filing a lawsuit in defiance of it and then maybe filing a discovery request or taking some other action, be held in criminal contempt?
They couldn't be held in contempt without receiving notice and an opportunity to be heard, and so I think that they would have an opportunity.
There's always that opportunity to be heard before criminal contempt proceedings, but could they then be held in criminal contempt, consistent with procedural due process?
Yes, so long as they had notice of the injunction, they could be.
Oh, so if they didn't have notice of injunction, then you're saying contempt is not possible?
That's correct.
Okay. Are you aware of another circumstance where an injunction's been issued where contempt's not possible?
Well, Justice Gorsuch, I think in any circumstance where someone didn't have notice of an injunction, contempt wouldn't be possible. That's really
Is the answer no, counsel? You're not aware of one?
I think that it's actually every injunction operates that way.
Because every other injunction provides notice in advance, and this one doesn't. So this one uniquely alone wouldn't allow for contempt proceedings. Is that your argument?
No, the district court specifically tried to facilitate notice by providing.
Counsel, if you could answer my question, please. All right, you're saying that they can be entered without notice. An injunction can be entered out without notice. You're not aware of one prior to that. And I'd just like a straight answer as to whether those individuals in these circumstances could be held in criminal contempt or not.
If they did not have notice of the injunction, then no, they cannot be.
Then is this an advisory opinion saying don't file these things, we'll throw them away, but we have no contempt power to enforce the injunction?
No, because the injunction does appropriately bind Texas, and it does appropriately bind all of those individuals who exercise the state's enforcement authority.
What is an injunction without enforcement power?
There would be enforcement power here, both with respect to the state, with respect to the individuals who have actual notice and file these suits, with respect to the court personnel who would violate the terms of the injunction, and with respect to the enforcement agents at the end of the day who would be enforcing these judgments.
On the Deb's question that the Chief Justice raised, just to press that a little bit further, and an assertion of an equity right here, and I think Justice Thomas alluded to this too, has the United States government ever before asserted this equity right to protect individual rights in any other state, ever?
Well, I want to be clear that the right that we're asserting here is to protect the supremacy of federal law. So
and I'm asking, have you ever done that to defend the supremacy of individual rights in any other situation anywhere in the country in our history?
We have brought suit before. It was a series of cases in, I believe, the 1970s that did not work their way up to this court. The United States urged a broader theory there to be able to sue to vindicate constitutional rights generally, but that's not the argument that we're making here. Instead, we are arguing that the specific thing that gives
Besides that one suit, are you aware of any others?
No, I believe there were 3 suits in that line.
Thank you.
Justice Kavanaugh?
General, in the prior case, the plaintiffs would be the same plaintiffs if it were an ordinary ex parte Young situation. General Stone would be representing a state DA or state executive official. We'd have arguments about the merits, which we're obviously not dealing with today, but it would be the same basic situation. There is an extension of ex parte Young to get to the prior cases we've talked about, and that's an important step that we have to analyze. Your case, by contrast, though, seems, and I'm probably repeating others' questions, just different and irregular and unusual, and we don't know where it goes. And if you could fill in, and maybe this will be repetitive, but you think the U.S. has authority to bring a suit like this against any state law that
violates this court's precedents and tries to shield that violation from any effective judicial review in federal or state court. And I recognize, Justice Kavanaugh, that this is an unusual suit. The United States does not lightly invoke an authority like this to sue a state. The reason we've done it here is because SB 8 is so unprecedented, extraordinary, and extraordinarily dangerous for our constitutional structure. If Texas is correct that it can nullify this court's precedents and it can successfully evade the mechanisms that this court recognized in Ex parte Young and Congress recognized in Section 1983, then no constitutional right is safe. And we think that in this extraordinary circumstance, the United States has a sovereign interest in intervening to protect the supremacy of federal law.
What if our precedent on something in a different area of law altogether was just uncertain? There was an open question about something, and a state wanted to kind of draw a line with respect to the precedent. Would the U.S. have the authority there? Is there something about what you think is the clarity of the violation here that triggers your authority?
If the state structured that hypothetical law in this same way, then we would have the same concern that the state is effectively seeking to take the issue away from the courts. And so you can imagine a circumstance where a right is more unsettled. Imagine, for example, in a pre-Heller circumstance, the right to possess handguns in the home. If D.C. had enacted a law that deputized members of the general public to seek these kinds of suits against that conduct, even before the court had clarified the right, I think that would have raised the same concern that effectively the state is seeking to box the judiciary out of being the final arbiter of constitutional rights. Now, I will say that I think that a state is far less likely to engage in this kind of mechanism with an unsettled right because it would think that its law is constitutional, and I would assume that it would want to forthrightly defend it and get a court ruling that confirms that point. But if a state instead sought to shield the law through this mechanism, it would raise the Supremacy Clause concern.
Thank you.
Justice Barrett?
I just want to follow up briefly on the questions that Justice Kagan and Justice Sotomayor were asking you about what happens to your suit if the plaintiffs in the whole women's health suit prevail. Let's imagine that they do prevail on a theory that the Attorney General has this residuum of authority and that the private parties can be bound as state actors pursuant to Rule 65. You told Justice Sotomayor that then the United States' interests would not dissipate even in that scenario, and I guess I didn't understand that. You phrased it, I think, in the past tense, that wouldn't cure the affront to sovereignty that was already there. But, the force of your argument for equity here is the inadequacy of a remedy at law because of the way that Texas has cut off access to the Ex parte Young remedy. So could you just explain to me why your suit would continue to be live or why there would be an argument in favor of it if Justice Sotomayor's hypothetical were in play?
Yes, of course, Justice Barrett, and I appreciate the chance to clarify. I don't mean to suggest that the suits wouldn't interact with each other with respect to what kind of equitable relief would be appropriate. I understood Justice Sotomayor to be asking me whether our suit is effectively contingent on the whole women's health litigation, and my response was that you have to measure the sovereign injury here at the time the statute was enacted. And when the statute was enacted, it was clear that Texas was seeking to deprive others of having an opportunity to go to federal court for a remedy. The law was unsettled. And it was apparent, and in fact has been the effect, that Texas has succeeded in being able to nullify the right currently while these cases are working their way through the courts. But I do think that if this court provided guidance in whole women's health and made clear that a state cannot succeed with what Texas has attempted to do here, then we wouldn't have that same circumvention concern in the future. But in all candor, the concern is that then a state might seek to legislate around whatever the whole women's health. And I think that what that shows is that when a state attempts to thwart judicial review and creates that possibility that the supremacy of this court's decisions will not be respected, the United States may sue in equity to redress that harm.
So it would be kind of a pile-on injunction? Like they would have an injunction against the Attorney General and the private plaintiffs acting, as state actors, and then we would also enjoin, let's say that we didn't want to enjoin the clerks and the entire apparatus of the state. Let's say that we thought you too, in getting an injunction against the state of Texas, could really only obtain one against the executive officials who would enforce the law. You're asking just for the same injunction in your suit, but just acknowledging that the United States has the ability to bring this kind of in re deb suit?
Well, I think that it's important to separate out the question of authority to sue with what kind of relief might be appropriate. So we do think that when we filed this suit, and at that point, of course, there was no relief being provided on the ground in Texas. This law had taken effect, and it had chilled a constitutionally protected right out of existence, that at that point we were authorized to bring suit. The question of what the appropriate remedy would be, I think, is a separate one, and I think it very well could be the case that there would not be a need for duplicative injunctive remedies in both of these cases, but that's a separate and distinct question from whether we could sue in the first place.
Thank you.
Thank you. General Stone, welcome back.
It's been a long time. Thank you again, Mr. Chief Justice, and may it please the Court. The Department of Justice's suit offends the separation of powers by usurping for the executive branch the role Congress plays in determining what cases may be heard and what remedies may be provided in the federal courts. As discussed earlier this morning, no Texas official is a proper defendant in a pre-enforcement challenge to SB 8. The United States cannot cure that problem by naming the state of Texas as a nominal defendant and then asking for relief that runs against the same Texas officials that are inappropriate targets for an injunction under Bedrock Article 3 and equitable principles. Moreover, the United States is not a proper plaintiff. It cannot claim a sovereign interest in suing to enforce individual rights under Casey, and the remedy it seeks would be completely foreign to traditional equity. Congress must create such novel remedies if they are to exist at all. And Congress has impliedly rejected giving the United States such relief by providing other avenues to vindicate 14th Amendment rights. Like the petitioners in Whole Women's Health, the United States asks this Court to disregard all of this because it deems SB 8 a novel solution for which a novel problem for which this Court must concoct a novel solution. Even if it were, and it is not, such a request must be directed to Congress. The United States cannot seriously assert that the Constitution requires pre-enforcement federal judicial review. It opposes that result in virtually every other case. This Court should reject its request for a special forum, remedy, and cause of action for this case alone. I welcome the Court's questions.
Is there any instance in which the United States can do what it's doing now that would be acceptable to you? That is that, let's say there is no question whatsoever that a state is defying a national law or a federal law or a constitutional provision, such as, for example, the Second Amendment. Is there any instance in which the United States can step in?
So, Your Honor, I have to first clarify. Are you saying with a cause of action provided by Congress or only in this in re debs style?
In re debs.
Your Honor, to the extent that Congress had provided either a proprietary right or had recognized a public harm in the form of a statute, for example, the Interstate Commerce Act, and then also the United States was seeking a traditional form of equitable relief, such as in Debs to abate a public nuisance, then it could proceed.
So a very narrow set of cases.
Yes, Your Honor, but some.
A separate question. I'm interested in the cases that are proceeding in state court. This is a carryover from the first case. What remedies could be provided in those cases if they were allowed to proceed?
Well, an individual could receive, for example, an injunction preventing the bringing of an enforcement action or by bringing a lawsuit by a plaintiff who seeks to do so. Now, of course, as discussed earlier to Justice Barrett, that would only provide relief as against that one individual. But the more important part here is that eventually those sorts of cases be decided on stare decisis grounds by appellate courts, which would prevent follow-on cases to some extent. But in terms of relief, you get declarations, basically, under the Texas state system. A declaration that an application of SB 8 against an individual — I misspoke earlier with an injunction, I'm sorry — that a declaration that an SB 8 claim by that individual against the protected conduct that someone's raising would violate state law, federal law, whatever the claim might be.
And one final point, why wouldn't, and I think I've alluded to this before and asked this before, why wouldn't these private individuals be considered private attorneys generals? Because so much seems to be, one thing that seems rather implicit on the other side is that they are in effect, if not in designation by law, attorneys generals, because they are enforcing a statewide policy. So your argument, again, would be that they are not private attorneys general because, or they are not acting in concert, they're not deputized, they're not agents because they're not subject to the state's control, they don't have access to the state's investigatory resources, the state can't at some point, for example, or take the case over like in a key TAM action, those sorts of answers that I was providing earlier, Justice Thomas. But my answer would run specifically to the lack of control between the state with regards to an SB 8 private plaintiff suit.
Let me think about just a specific example, which was the worst one I could think of for you. Suppose the Governor of Albus, had this model law and said anyone who brings a black child to a white school is subject to, and then we copy the law. There we are. Now, if you were in that situation, which I'm sure you're glad you're not, what? What would you do? I mean, if we uphold this, are we retroactively upholding that?
No, Your Honor. As a matter of fact, for that very specific case, Congress has specifically provided DOJ.
No, this is before Congress. I mean, at 57, Congress was no help. I mean, believe me, they did nothing. Or if they did something, I'm unaware of it. And if they did something, I assume it out of the hypothetical.
Fair enough. Fair enough, Your Honor. The answer would be that there would have to be recourse, again, to the state court. I'm assuming this is a state legislature because we're talking about federal court.
This was Arkansas in 1957.
Sure, Your Honor. And that, in fact, that court would be obligated to apply this court's decisions. It's a transparent violation of the 14th Amendment, of course, Your Honor. We have to assume that state court judges
— Yeah, but they didn't. I mean, we have some experience. And most of those cases that came up in that period to this court, the judges were aware of that experience, and they tried to shape the law to avoid it. So is there anything you can think of? I'm getting your answer is no. You cannot think of anything. The only thing we would have to have said then is it's up to the state of Arkansas's judges.
The problem, Your Honor, is that the number one answer to your question is the thing you've asked me to assume away, which is the thing Congress has actually done, which is in 42 U.S.C. 2000 C6 specifically provided a cause of action for the United States to maintain a cause of action under the Equal Protection Clause.
Can I give you examples where Congress has it? A state dissatisfied with Heller says anyone who possesses a firearm anywhere is subject to litigation by any private citizen anywhere in the country and gets $1 million bounty. No stare decisis, no nothing. How about in Obergefell imposes SBA-style liability on anyone who officiates, aids, or abets a same-sex wedding? How about dissatisfied with Lawrence versus Texas, subjects a private consensual sexual conduct of which it disapproved to the exact same law as SBA 8? How about Griswold? The use and sale of contraception is subject to SBA-style liability. So this is not limited to abortion. That's the point that's been raised. It's limited to any law that a state thinks it's dissatisfied with.
Your Honor, I've at no point in the earlier argument or this one asserted that the extent of federal courts or federal court availability turns on the underlying right here. Quite the opposite.
So
I agree with you,
your
it
point
doesn't.
is that no matter how much a state intends to chill the exercise of a constitutional right, as the Chief said, imposing $1 million liability for an act, which I think almost any sane person except a couple of billionaires might choose to resist, that does not give anyone a right to a federal forum when the state has deputized every citizen to act on its behalf.
No, Your Honor, it does not create federal jurisdiction as a consequence. I do want, however, in the spirit of the hypotheticals you're delivering, want to return to a point that Justice Barrett made at the end of my friend's previous argument. At a very minimum, to the extent that this Court believes it has to somehow alter the ex parte Young fictioner, et cetera, to find a way to allow the plaintiffs in Whole Women's Health to proceed, at a minimum, the United States' case must thereby fail. The United States just conceded up here that whatever interest they had would be purely retrospective, as of course, there being some sort of ability to vindicate the rights that Whole Women's Health and other petitioners are trying to provide. They only seek a preliminary injunction, which is by definition exclusively prospective relief, and they cannot possibly maintain their action any further. It goes exactly one way. If the petitioners in Whole Women's Health have some sort of avenue of relief, then the United States must not. Which makes sense given for the extraordinary cause of action that they're trying to bring here. Congress has provided the United States, certainly at times, sometimes with truly extraordinary powers, such as the power of preclearance in the Voting Rights Act, to give one extraordinary example. The United States here would want effectively a follow-on injunction for, in their words, in the event that the state of Texas changed its law or otherwise tried to, in a way of uncharitably putting it, if the state of Texas changed its law to comply with with this court's law, and yet nonetheless have something like SB 8. We have a term for when a state is put into a state where they have to get the federal government's approval before it makes a relevant legal change, and that's called preclearance. That's precisely the kind of injunction my friend on the other side was speaking of. So it can't possibly be the case they'd be entitled to that sort of remedy, just as a matter of course, in the event that Whole Women's Health succeeds or prevails to any extent. That's just one component of the extraordinary expansion. Sorry, Justice Kavanaugh, I thought you were going to ask me a question. Just one component of the extraordinary expansion of federal power that the United States is asking for here. Not only are they claiming a brand new sovereign interest, which can be synthesized one of two ways, either in ensuring the vindication of individual rights underneath this court's pronouncements in Casey in substantive due process, or apparently a sovereign right to ensure the expansion of access to the federal courts, because after all, Section 1983 and Congress's various statutes that compose the federal courts, they stand as they stand. Texas understands them as is this court. They stand for what they are. The United States can't possibly have a sovereign interest in extending the application of those doctrines to apply to cases to which they don't, just because they deem this a very important case.
General, if I understand your answer to Justice Sotomayor, it was, well, even if that's a really good question that I don't have an answer to in the other case, I do have an answer to it in this case. And that's fine. That's, here you are, we're in this case now. But I guess I just would like to take you back to the other case and to ask you to answer the question that you said you wanted to avoid for Justice Sotomayor.
I'm sorry, Your Honor. I thought I'd agreed that it doesn't depend on the nature of the right being asserted, and that also we could sort of raise the potential sanction as high as possible, and that wouldn't affect federal court availability. I'm sorry. I thought I'd answered that, but to make my answer expressly clear. Okay. The other dimension in which the United States is asking for an extraordinary power is the nature of the remedy they're seeking.
I guess I do want to ask a question about that, though. I mean, if that's right, and we say that, we would live in a very different world from the world we live in today. Essentially, we would be inviting states, all 50 of them, with respect to their unpreferred constitutional rights, to try to nullify the law that this court has laid down as to the content of those rights. I mean, that was something that until this law came along, no state dreamed of doing. And essentially, we would be like, we're open you're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead.
Respectfully, Your Honor, I have to disagree with you on 2 points. The first one being the state of Texas hasn't nullified anything. The state of Texas specifically set up in state law a recognition of this court's holdings in Casey, providing an undue burden defense, particularly to recognize that this court's holdings bind state courts in their adjudication. And, of course, the federal constitutional right can and must be made available in those state courts regardless. The second point being, to the extent that we're talking about sort of the extremist hypothetical where it's a $5 billion sanction, and by the way, court is on the moon.
But by the way, this seems a pretty extremist hypothetical actual, I mean, because the actual provisions in this law have prevented every woman in Texas from exercising a constitutional right as declared by this court. That's just not a hypothetical. That's an actual.
That's just not true, Your Honor. There's evidence in the record that estimates that the number of abortions occurring right now in Texas is between 50 and 63%.
I'm sorry. You're exactly right. I should have said every woman in Texas who has not learned and has not made a decision before 6 weeks.
Respectfully, Your
let me put a time marker here at 1:00:52. We're definitely over time, so I'm going to say thank you to those who are listening. We're going to go and stop the recording. We'll have some discussion here, and we'll come back at this the last 30 minutes next week. All right, so let me go ahead and say thank you to those who've watched, listened, and see you next time.